Okay, welcome back to Second Nature. We are joined by a very special guest. That is Ian Gates from Colich, Romano, DeCenzo, and Gates in Portland, Oregon, an IP attorney that has helped both Aaron and myself navigate the worlds of trademarks, etc. So Ian's going to educate us on the importance of protecting your intellectual property if you are working on building something for yourself in the outdoor industry. Ian, welcome to the podcast, buddy.
Thank you. Great to be here. It's good to see you guys.
Lucy, maybe share your experience working with Ian real quick, and then we'll launch into what makes his work so important.
Yeah, absolutely. You were actually the person who connected me with Ian way back in the day when I was getting Super Rider off the ground. And Ian worked with me really closely to get a trademark for Super Rider. Not only, I think, the logo itself, but the concept of what I was trying to do with it. We worked and talked through all that stuff. And the thing that blew my mind more than anything is just how much I didn't know about any of this stuff. Like, I just want to go out and make really cool content and have a cool brand and just go, go, go. And Ian was really helpful to just be like, okay, time out for fun. Let's talk about the stuff that's important for your long-term success. And let's make sure that you do this the right way. And I felt after that conversation that I knew so much more and that I was capable of actually, being successful long-term. And I hope that, people take away just a little nugget of Ian's wisdom today. They'll be in a way better place.
There is a sense of relief in knowing that you own the mark and the brand in the category that you operate within. And Ian has given me that peace of mind too, but it has been hard earned. Ian, you will remember that we went
How many did we go through?
Oh my God. We went through a long rebranding process to become Free Trail that Ian really shepherded our small team through. That took a lot of energy, a lot of resources, and ultimately we landed on a brand and in a place where we're super, super happy, and we can thank you. And most recently, Ian, you'll know that we protected Free Trail for use on apparel, hats, backpacks, things like that as well.
That's right.
So not only in the media space, podcast, coaching, I think, and a few other different categories, but also on products as well, which is something that we're starting to make progress on. Big thank you to Ian. All right, Ian, so let's start with a quick primer. Just give us a sense of who you are, what you do, why it's important for outdoor operators to think about protecting their ideas and their IP.
Yeah, thank you. So glad to be here. I am an intellectual property attorney, which means we help clients protect their IP, both on the front end as well as in enforcement. There's kind of four buckets of intellectual property. There's patents, trademarks, copyrights, and trade secrets. And you guys focus on BPC here on Second Nature, and that, is basically teeing me up perfectly because B is for brand, that's the trademarks. We help clients protect and enforce their trademarks. Product, that's going to be the patent side of things, both utility and design patents, and we can get into that. And then content, that's protectable by copyright. And then trade secrets is kind of the fourth main bucket of intellectual property. And that's going to be anything that is valuable to your company, your brand, your product, but that is secret, that's subject of reasonable means of secrecy. So that could be things like a future product you're working on, but you haven't launched it yet. It could be a future brand that you're working on and you haven't launched it yet. So things that you don't want your competition to know about necessarily, but that is valuable to what you're working on. So those are the four main areas of intellectual property. Some other areas that we help clients with in this space could be things like influencer agreements, co-branding agreements, athlete sponsorship agreements, anything that has to do with this non-tangible property that we call intellectual property.
So I know in the thing that I would love to hear you talk a little bit more about, because I have no understanding about it, is this confidentiality and trade secret side of things. Because, for what you've worked with Aaron and I on, that has not been the case, but with bigger brands who are creating new innovative product, that's probably a case where you help them protect that new technology prior to it being publicly available. And I know you mentioned that there was some sort of a lawsuit as it relates to golf clubs. Is that right?
Yeah. So first of all, to protect a trade secret, we're not really helping the client protect it other than giving them advice. That's really on the client, and it has to do with having confidentiality agreements in place with your employees, with your vendors, with your suppliers, having passwords on your computer, locks on your door, that kind of thing. And so, yeah, we're involved in a lawsuit right now. I'm not going to mention the client, but it's a case where, like, the vice president of engineering decided to leave a company, and then the next thing you know, he started a competing company, and there's a product on the market that looks awfully similar to something that his former employer was working on.
Mm.
And that, but once the cat's out of the bag, once he's launched that product, it can't be a trade secret anymore because it's out there in the public. Anyone can buy it, reverse engineer it. And so what we have to do is rely on the trade secret laws, rely on contract law to go after this company and this individual. And we were successful in getting a preliminary injunction against him to shut down sales of this new product. So that's a great example of how important it is to make sure your inner team is bound by confidentiality, or they can just go off and take your ideas, because otherwise ideas are just kind of free, right? They're out there, they're in your head. There's nothing, you can't stop someone from taking knowledge with them, but you can potentially stop them from using it in an improper way.
That's very interesting. So maybe you could use either Free Trail or SuperWriter or both as an example, just backing up a step
Sure.
about like the work that you did for us and why it's important, so like smaller businesses that have small teams
Yep.
like ours, how is that an important thing to think about from the earliest days of setting your little thing up?
Great question. So first and foremost, if you're a product company, which you guys are more of a service company, both of you,
For
right?
now.
You're putting out content for now. But on the product side, one of the most important reasons to keep things confidential is on the patent side of things. And that is, in the US, you have 1 year from your first public disclosure, your first offer for sale, or your first sale of a product. You have 1 year from that moment in time to file a patent application, after which point it's just considered in the public domain. And there's nothing you can do at that point. Most of the rest of the world doesn't give you that 1 year grace period. And so if you want to be able to pursue foreign patent protection, it's really important that you keep it completely buttoned up until we at least get an initial patent application filed, whether at the US level or at the international level.
So this trade secret stuff is fascinating, and I feel like Dylan and I are furiously taking notes over here because we're going to be using some of this stuff pretty soon. I would love to go back to the trademarks, kind of
Yeah,
like where we started with both
absolutely.
SuperWriter and Free Trail. Why do we need to do things like that? Why do we need to trademark Free Trail, and what do we get out of it? I guess just like from a very top line standpoint, and why should somebody else who's launching a brand be thinking about even trademarking the name of their brand?
Sure. So basically, what any intellectual property right does is it gives you the right to stop others from doing something. And so the reason you want to protect your trademarks is you want to prevent your competition from using your trademarks and, you know, making money off of your goodwill, people ending up at the wrong website, buying something by mistake. And trademark law is founded in consumer protection as opposed to necessarily brand protection, but it results in brand protection. And the test for trademark infringement is called likelihood of confusion. And so that's from the perspective of a hypothetical consumer. If they're familiar with their brand, are they going to be potentially confused or likely confused if a similar brand is out there selling similar goods? And from a brand protection standpoint, we don't want that because we're going to potentially lose sales, right? So there's two main considerations when a small company like you like you're asking about, two main considerations to think about and come talk to us about. First is the trademark distinctive enough to actually serve as a trademark? We'll talk about that. And second, is it going to create a likelihood of confusion with anybody's existing rights? Because you don't want to launch a brand, get a demand letter 6 months from now, and have to completely rebrand, right? So, Dylan, that's what we did a lot of searching to make sure we arrived at not only a brand you liked and that would serve as a strong brand, but that didn't have the potential of infringing someone else's rights.
So this is go ahead, Ian. Sorry.
I was going to say, on the distinctive side of things, we talk about the spectrum of trademark distinctiveness. So generic words, never protectable, right? So the word podcast for a podcast, you can't get trademark rights in that because that's what it is we're on right now. And everyone needs to be able to talk about podcasts. One step up on the spectrum are descriptive marks. These are words or phrases that describe the goods or services. So, outdoor podcast. You can't get a trademark rights in that because it describes what it is you're doing, and your competition, again, needs to be able to describe what they're doing. Above that on the spectrum is where you want to be. So there's suggestive marks. These are words or phrases that suggest an aspect of a product or a service. Free Trail and Super Rider are both great examples of suggestive marks because it tells you a little something about the brand, but not exactly what it is. And it requires the consumer to kind of do a little mental, acrobats to understand what's going on. Very powerful from a branding standpoint. You can do a lot. You can tell a lot of stories with suggestive marks. And then there's arbitrary marks. These are words or phrases that are in the dictionary but have absolutely nothing to do with what you're selling. So Apple for computers, for example. And then fanciful marks. These are words that are made up, but so there's really no reason your competition should be able to, use them. And just about any pharmaceutical name is an example of a fanciful mark. So you want to be suggestive, arbitrary, or fanciful. And suggestive is really the sweet spot because you can do a lot with your brand storytelling.
This is my new career, just coming up with fanciful marks.
Well, you can spend a lot of money on marketing, third-party consultants to come up with brands. That's for sure.
The Ozempic trail running shoe. Is that that's a fanciful mark that I would get sued out of existence for using? Yes.
So that's the distinctive. You want to pick a distinctive mark, and then you want to avoid infringing someone else's rights. And so that's where we come in and do a search of the rights that are out there. And the likelihood of confusion analysis is this fluffy legal test. It's not real clear. Like minds can disagree, but it's how similar are the marks. Do they sound similar? Do they look similar? Do they have similar commercial impressions? How closely related are the goods and services? And that kind of thing.
So this would be a fun, hypothetical example that we could walk through. And this is totally spontaneous. Ian has not been prepared for this. But for example, if a brand popped up called Freedom Trail, for example, and they were doing things that were very similar to us, using very similar language, launching similar products in spaces where we have trademark protection, what would then be our recourse, or in what cases would we have, a leg to stand on?
Yeah, great question. So the first thing we would do is we would decide whether it makes sense to object to them. If you clearly predate them, that means you have priority. So that's the starting place. Because a big no-no would be like, it turns out they've been around for 15 years and we send them a demand letter and they're like, no, actually you're infringing our rights and you just admitted that our marks are similar. So that's the first step. The second step is for us to do an analysis. How distinctive is the free trail mark? What's the breadth of protection we likely have for it? And if you're really the only free trail sounding mark out there, then you're going to have some pretty good breadth of protection. But if there's a freeway trail, a freely trail, if there's what we call a crowded field of other free blank trail marks, then it's probably okay for a freedom trail mark to pop up in there as well, because consumers theoretically are already used to distinguishing between these various similar sounding marks. But if you're really the only free trail in your space, then you're going to have pretty good case against the Freedom Trail mark and be able to make them stop. And we would usually start with a cease and desist letter, because lawsuits are so expensive.
And so basically it comes down to likelihood of confusion at the end of the day.
That's right. Yeah. That is the test for trademark infringement. Yeah.
And I believe what you did with us, where you did something called a knockout search, and that's kind of like your cursory look to just see how does the thing that you're trying to trademark stack up against both those things of distinctiveness and the likelihood of
That's right.
confusion?
Yeah. So a knockout search is kind of a just like you said, it's a real high level search. It's where we're looking for bright red flags. Oh, look, Aaron, there's already a super writer out there doing almost the exact same thing. You really should pick a different trademark. That was not the case for you, or for Free Trail. But it was the case for some of the other marks that we went through for Dylan, for example, where, there could have been, I can't even remember Dylan, but there may have been like a running short that was branded with one of the marks that Dylan had come up with before Free Trail, and and Dylan really wanted to have a future product line under the Free Trail mark, not just the podcast, right? We're thinking really big. We're thinking long term. We can't just clear it for a podcast. We've got to clear it for running races, for podcasts, for merch, for real athletic apparel and equipment and that kind of thing. Yeah.
So it's really hard, I mean, we should say, to come up with the right brand and the right name that doesn't have an existing competitor who could argue likelihood of confusion.
That's right. It is never, inevitably, it is never an easy yes. It's where are we on the risk spectrum?
Which is sort of why this is an important conversation to have and why people like you are important in the outdoor industry.
That's right. Yeah. And you really do need to talk to a trademark expert about it and not do it on your own, because there's so many nuances to it.
How long does it last? Like, once you get the actual stamp of approval, you got the trademark, which is not a fast process once you submit it, but how long does that protection actually last?
So it potentially lasts forever as long as you're using the trademark for the goods or services for which you have it registered. But this is an important place to step back for a minute and say that in the US, you don't actually have to register your trademark to have trademark protection. You have what's called common law rights just from putting a brand out there and having consumers interact with it. As long as you're not infringing someone else's rights, those common law rights come out of thin air, and you've got rights that you can enforce in court. But federally registering those marks gives you more enforcement options. And most importantly, it takes your common law rights and spreads them across the entire country. And it puts you on the federal books. So when competitors are talking to their trademark attorneys and doing their knockout searches and their comprehensive searches, they're going to much more readily come across your federal registration and steer clear of it. So there could be potential benefits happening in the background that we never know about when a competitor is doing their own trademark clearance searching, comes across your mark and avoids it. And we're never going to know about that.
Okay, so let's get to some practical examples here. One that I think is really interesting is the story of Joyride Snowboards. And they were sort of looking to revive an old legacy brand in the snowboard industry. Tell us about that. What was important about it? What were the challenges? And how it ultimately concluded?
So Joyride Snowboards is a client of ours, founded by a gentleman named Russell Taylor here in the Portland area, lives in Sandy. And he's like my age, I think, mid to late 40s, came up in the early parts of snowboarding in the 90s when snowboarding really was, first coming into being. And Joyride Snowboards was kind of the first kind of skate-influenced brand as opposed to more of the ski-influenced side of things. And so they came with a certain edge and a certain brand and a certain demographic that they were appealing to. And they didn't survive over the years of, how brands don't always survive. But that brand was always in the back of his head as just really important to him from when he came up as a snowboarder. And so he saw an opportunity to bring it back. I generally refer to that as a heritage brand. It's one that existed in the past but doesn't currently exist. And so he got together with the founder of the original Joyride and got permission to use some of the artwork and things like that. And we filed to federally register the Joyride Snowboards mark. We were successful with the examiner. And then out of the blue, maybe not out of the blue, we knew it was a potential, but K2, who owns Ride Snowboards, objected. And so when you file a trademark application, you first get examined with an examiner where they determine, is your trademark going to create a likelihood of confusion with any existing registrations? And if they approve it, it goes through a 30-day window called a publication period or opposition period, where third parties who are paying attention can object. And that's exactly what K2 did, saying that the Joyride snowboards mark would create a likelihood of confusion with the ride mark. And so we went through what's at the trademark office, what's essentially litigation over who should win that argument. Is there a likelihood of confusion between ride and joyride? And that takes 2 or 3 years and tens of thousands of dollars potentially, if not hundreds, for big brands that really fight these things out. Ultimately, we were successful in arguing that the ride mark that K2 is enforcing against us is really weak, right? Because that's what you do on a snowboard. They never really should have gotten that in the first place. And interestingly enough, there was a dispute between Ride and Joyride back in the 90s, and Joyride was actually the senior party, the one objecting to Ride. Joyride ended up going out of business. Now we're reviving Joyride, and K2's, now the senior user. So anyway, culminated in a win for my client, which was just a huge victory, I felt, for the little guy in this particular case.
So there's actually there's a brand out there called Joyride that Ryan Trahan, the YouTuber, runs, and it's like a candy brand with the same exact name. So when you go back to distinctiveness, it's the same name, but likelihood of confusion, snowboards and candy, you're
completely
good.
Unrelated. That's right. Yeah. But let's say there's a ski company called Joyride. Well, that's going to create a confusion because lots of ski companies also have snowboard brands. Or maybe there is a backpack brand called Joyride. And well, ski companies, snowboard companies also put their mark on backpacks. And so that's a little bit closer than the candy example. So we've got to figure out where are we on that relatedness of goods and services, and what are consumers truly likely going to be confused about?
Okay, so there's another concept called trade dress. This is under sort of the overarching theme of trademarks. Tell us a little bit about that before we get to patents.
Yeah. So trade dress, there's two types of trade dress. There's product configuration and there's product packaging. So it's not the word, the logo, a slogan, anything like that. It's the way your product or your packaging looks. And basically anything that when a consumer sees it, recognizes it as a particular brand, can serve as a trademark. So if a product looks a certain way, and that's the only product out there that looks that way, and consumers immediately recognize it, oh, that's a whatever, then that serves as a trademark. And you can protect that both under the common law and you can federally register trademarks. So a good example is Rumpel, our client. They make blankets, right? How do you get protection in blankets? Well, they've got a unique look. They have unique stitching patterns that only they use. And when you see it, if you're familiar with the brand, you recognize it as a Rumpel blanket, even if you don't see the word Rumpel on it. So trade dress can be quite powerful because, again, trademarks can last forever, where design patents, which we'll talk about, have a limited life. But trade dress, if you're successful in getting protection, can last forever. The thing about trade dress, though, is on the distinctive side of things, by law, it's never what we call inherently distinctive. So you have to earn that distinctiveness. You have to prove to the trademark office or to the court that your product, the look of your product, has become distinctive in the eyes of consumers. So you can't, on day one, launching a product, have trade dress protection in it.
Very interesting. So I think we should say here, as we kind of transition from trademarks to patents, that Aaron and I have teased a couple of times here on the podcast that we're working on creating a small niche brand in the outdoor industry with a small niche product, at least to start. And you're helping us with the trademark process and hopefully eventually with the patent process. So feels like an elegant transition here. Again, you said that trademarks apply to brands, patents apply to products. Actually, one thing that I think would be interesting that our listeners will be familiar with that might tie this together with previous podcasts. Last week, we talked about the new light spray from On Running, where they sort of have this new technology for uppers of running footwear. And Aaron had speculated whether the inventor of this technology had a patent that he sold to On. So obviously this is also spontaneous. You're not prepared for it. But if there's anything you can say about, those like very specific technological advancements and how
Yeah.
bigger brands would go about protecting that, and to what degree they can protect it, because obviously, as we know, as soon as these new innovations happen, everybody else starts copycatting.
That's right. So yes, this is very much the realm of patents. In the US, there are two types of patents. They're design patents and utility patents. Design patents just protect the look of a product, the contours, the shape, or any surface ornamentation on it. So in the case of and what was the On
It's called
technology called?
light spray.
Light spray. So that results in a unique look of a footwear, right? And so they can pursue design patent protection on that look. And that, if they're successful in getting that, it'll prevent others from making, selling, offering for sale, or importing anything that has that look that they get a design patent on. The utility side of patents protects the structure, the function, potentially the manufacturing method that goes into it. And for any invention to be patentable, there's two main requirements. It has to be novel. So you have to be the first person in the history of personkind to have invented whatever it is you're trying to get a patent on. And second, it has to be non-obvious, and that's the tricky part. That's where we spend the bulk of our time arguing with examiners at the patent office. And it's from the perspective of a hypothetical person of ordinary skill in that particular technology area who's presumed to know everything there is in that technology area. So in the case of On's technology, it's going to be a footwear industry person who's familiar with engineering footwear, uppers, and is what On came up with just an obvious combination of things that's been done in the past. Inevitably, when we file a patent application for a client, we're going to be rejected as being obvious. It's almost always the case, but it sets up a back and forth between us and the patent office arguing about what's obvious and what's not obvious, what really makes the invention unique and gets beyond that threshold of obviousness. Go ahead.
Well, I was going to say another kind of example of this is really interesting. So, when super shoes, the advent of super shoes in trail running, or I'm sorry, in running in general occurred, and that immediately was measurable improvement for athletes, both world record setting athletes and middle and back of the pack athletes. Nike was the first brand to introduce that product to the market. And I know they patented that original 4% shoe, but then there's of course, now all the big brands have their analog, but there's slight design differences. Is that how they kind of get around Nike's original patent?
Potentially, and I don't have Nike's original patent in front of me, but the question is what does that patent cover? My job as a patent attorney for my clients is to try to get as broad of a patent protection as we can, not just the specific product they're selling, but as much as we can protect the concept and variations on that concept and variations on that client's specific product. But absolutely, a sophisticated competitor is going to look at that patent and they're going to try to figure out how can we design around it? How can we avoid this patent but still have a competitive product? Sometimes that's easy. If the patent's really narrow in scope, you just have to tweak one or two things and maybe it performs just as well and you avoid infringement. But in an ideal world, it's super broad protection. And certainly for kind of first of their kind inventions like Nike's, my hunch is it was pretty broad. But patents have a limited life. They last from the date of issue till about 20 years from when they were filed. So if it took 3 years to get a patent only can last about 17 years. And then once they're expired, they're in the public domain, so anybody can use that technology.
I've got to imagine that Nike would have just gone for like having a carbon plate in the shoe.
As a starting place, sure, yeah. But, footwear is interesting. We've got a handful of footwear clients. I mean, a carbon plate in a shoe is essentially a shank, and shanks have been in shoes for, several hundred years. And so you've got to distinguish it more from just having a rigid piece that goes down the middle of a sole assembly. You've got to get into the dimensions, the specific materials maybe, but Nike didn't invent carbon. They didn't invent carbon fiber. They're probably using someone else's carbon fiber technology, at least initially. So what is it that makes their carbon fiber shank unique that gives a running shoe different from, say, a men's dress shoe that has a shank in it? How is it shaped differently? And most importantly, why does that shape result in a technological advantage as opposed to just what we call a mere design choice or something like that?
So here's an interesting question for you as we're just riffing on these patents. In an M&A process, if a brand is selling to a private equity firm, a larger holding company, existing patent protection probably makes that business a lot more valuable.
That's right.
I'm a partner in Speedland, the footwear brand out of Portland, and they have a patent on their removable carbon plate innovation. Again, I
Yep.
don't know exactly what the confines of that patent actually protect, if it's the process by which it does anchor back into the shoe, or if it's the removability period, because they were the
Right.
first people to actually create that innovation, the ability to take a carbon plate and put it in and take it out. But maybe comment on that a little bit about how a patent might increase the enterprise value of a business once it's
Yeah.
protected.
So the value in a patent comes in the right to stop others from making, selling, offering for sale, or importing whatever it is you have a patent on. So if an acquiring company sees that value or doesn't see that value, then they know that if we buy this company, there's nothing going to stop, On or Nike from copying Speedland's technology. But if that patent is in place, it gives them the peace of mind that, oh, we've got something unique here and we can hold on to it for quite some time and really have that competitive advantage because of it.
So I'd love to go back to just the different kinds of patents, if we could.
Sure.
You mentioned there's like a design and a utility patent. We talked about, I know previously we talked about trade dress. Is that pretty similar when it comes to design, where it's more of like the look and feel of the product itself?
That's right.
What's the
They're
difference?
very similar. It's just a slightly different scope of protection. I don't know the history of where design patents necessarily came from versus trade dress, but the cool thing about trade dress is it has the ability to last forever, like we talked about. As long as you're using it and consumers recognize it as a source identifying product, then you have protection there. But trade dress is going to probably be limited, not limited, but it's going to rely on what consumers are perceiving. Is it the entire product or is it one little aspect of the product? Design patents, we can protect one small little aspect of a design as long as it's novel and non-obvious from an ornamentation standpoint, from an aesthetic standpoint. So I'll give you an example. We used to represent Camelback. Let's see. And so this is their coffee mug from several years ago. I'm not sure if they're still making this version, but we were able to get design patent protection on the overall shape of the lid, on just the shape of this piece right here, just the shape of the handle. So you can create kind of a portfolio of design protection around a product and prevent others from copying those aesthetics. A brand like Camelback, they've kind of carried, at least over the years, the look of their handles from product to product. It's morphed over time. But when you would see, from a trade dress standpoint, if I go into REI and I see the shelf of Camelback bottles, I don't need to see the Camelback logo to know it's a Camelback because I just recognize it. So that's trade dress, because as a consumer, I immediately know it's a Camelback. But the design patent allows me to protect something more specific or something even smaller and unique. And design patents last for 15 years from their issue date, whereas the trade dress can last forever.
And then the other kind of patent is the utility patent.
That's
correct?
right. And that protects the function, the structure, or process that's unique.
So that would be the removable carbon plate example.
That's right. Yeah.
So you have a couple of interesting practical examples here, which I think really helps to sort of drive the point home. One, a footwear product from Avoli. Why don't you tell us a little bit about that?
Yeah, I believe they pronounce it Avali. and it is a company here in Portland, started by a couple footwear veterans from Lululemon and Under Armour, I think is their history. And they're both dads of volleyball players. And they were seeing these girls wear men's basketball shoes and cinch them up tight and not really have a dedicated brand to volleyball, which happens to be the largest sport for girls in the United States. And so they saw a real opportunity here and they innovated some really cool stuff. And I've got a deconstructed shoe here. One thing they've done is they've added ventilation to the sole because volleyball is played indoor on a court, right? You don't need to wear this shoe outside in the mud and the rain. Um, and so why not have really good ventilation? Because that was one of the thing the girls were complaining about was how hot and sweaty their feet got. And they'd go to these weekend tournaments and their feet would be drenched in sweat and they'd go back to the hotel room and use the hair dryers to try to dry it out before their next game. So, but putting a hole in a sole of a footwear is not an intuitive thing necessarily, and you've got to get that ventilation all the way up through to the footbed.
Mm-hmm.
And so they did some real unique things with these perforations and with these holes. And what they actually found is when the players are using these and they're stepping, it's actually drawing the air in from underneath and creating like this active cooling. So that's a really cool technology that we've never seen in footwear before, but it's unique to their sport, right? Like you're not going to have a trail running shoe with holes in the bottom. I guess you could see maybe a road running shoe that way, as long as it's not in Portland, Oregon in the winter. And then the other thing they did, which was really unique, and I think touches on the branding side of things and how you can be creative with branding and product, is they came up with this. I don't know if you can see it, but it's actually a translucent sole where they put their branding underneath it. But what that allows them to do in the manufacturing process is customize shoes for sports teams. So you could, a college volleyball team could have their logo or their name put here, and they don't have to completely retool their manufacturing system. They just put a different sticker, different piece of paper inside the sole. And so from a manufacturing standpoint, they can do some huge branding. They can change the colors, they can change the trademark, the logo, all that kind of thing, and make it specific for a team.
That is very cool. Aaron, this reminds me of a conversation we had on the phone this morning. Are you looking at a volley here, Aaron?
No.
Very interesting. It looks like a very cool product. And for our listening audience, Ian has been holding up examples of the Avali product and the technology that it sounds like you are helping them protect. So if you're just listening to this, you may want to check it out on YouTube. But maybe an interesting thing to introduce into the conversation here, Ian, without giving up anything that we're working on, Aaron and I, one of the things I said to him this morning is like, there isn't really a brand in this particular category that has anything aspirational about it. And this seems to be the case with Avali. Avali is basically operating with the founding insight of there is not a brand in women's volleyball footwear.
That's right.
It might be a smaller market than, men's and women's running shoes, but it's a market nonetheless. And they're trying to be the brand in that market, which is kind of the thing that we're trying to do in our little category too. Lutz?
That's right.
Yeah.
Yeah. And that is huge, because if you can be the first to market in that space and be innovative with products and potentially protect those products with patents, then you can really hold that niche for a longer period of time while you grow market share, while you just get bigger and bigger until you explode.
That's actually, it feels like a really important message there too, Ian. Like, brand is obviously really important, having something distinctive, different, memorable, but it's the combination of having good brand and innovative product where, really successful businesses are built.
That's right. Absolutely. I mean, and this has come up, I think, on the podcast a few times where, anyone can slap a logo on a t-shirt, right? can you build a long-term strong brand around that? Well, not if it's just any t-shirt, right? It's got to be a high quality t-shirt, or it's got to go along with the content. I'm thinking of the TTL guy, right, that you guys just had. There's a story there. People want to follow that brand, but they're not necessarily innovating their own merch, but they're picking high quality merch to ensure that their brand is only associated with high quality products. But if we take that to the next level and we talk about innovation, then that's huge, right? Because you really own that niche, and you're the only one who can sell that product if you've got strong patent protection for it.
Big fan of the Avali line here. Hits different. It's kind of awesome. I'm on the site now. This is really impressive. And yeah, they completely own this whole volleyball world. Any other brand is going to be, maybe they make something
right,
that's
like, you know,
relevant to
Nike
volleyball.
and Adidas probably have a volleyball shoe, but it's not, they don't have a brand wrapped around it, right? It's kind of we're going to tweak a women's tennis shoe and call it a volleyball shoe, or we're going to tweak a basketball shoe and call it a volleyball shoe. These guys are really the first ones to see that market and go after it.
That's something that we have talked about on the pod a lot, of just like the nicheification of a lot of these brands, which makes it harder for the larger brands that play across sporting categories to feel authentic to a consumer who really only cares about one particular sport. In other words, like, it might be easier for someone to start a new trail running brand that focuses only on trail running than it would be for a Nike or an Adidas to come into trail running and feel authentic to
That's
a
right.
consumer. Is that something that you feel like is becoming more the case now in the internet era, where niche brands are having an easier time, as long as they have good brand and a good product, in finding a market?
You're asking me or Aaron? Me?
Well, I mean, yeah, I'm sure you interact with a lot of these smaller businesses. Yeah.
Yeah, and those are who we like to work with, right? Because those are the people that are passionate about what they're doing. It's not just a throwaway product line. It's not just another something. From an intellectual property attorney standpoint, yeah, we love seeing that, and the passion really comes through in their branding, in their efforts, in their product. And absolutely, I think that's important and results in who's successful and who's not.
Mm-hmm.
Yeah.
It's got to be so cool to have a front row seat to all this stuff. I mean, I'm sure there's all kinds of stuff that you can't talk about, but you're getting to see like development of stuff, you know, the trade secret side of things, or stuff that's in development, even the stuff that Dylan and I are working on.
That's right.
But
Yeah, no, it's a
gotta
lot of fun. Yeah.
So fun. I mean, this is like your like real life too. You care about this stuff on top of being really good at doing all the hard paperworky type things that go with it.
Well, and to be a patent attorney in the U.S., you have to be an engineer or a scientist first. And so we all have engineering or science backgrounds here, but we're not making our own products, but we're getting to go along on the ride with all our clients that are coming up with their own stuff, and that's what makes our job interesting. We learn so many new things day in and day out.
Very cool. What's probably a little bit less fun is the actual litigation and enforcement of a lot of this stuff.
That's right.
But we should talk about it, because I'm sure that's really important. First of all, like, how do you stay vigilant? In what circumstances is there an alarm bell that rings of like, hey, we need to protect our client's IP in this situation? And what are the steps after that?
Yeah, so a lot of it is the client themselves paying attention to what their competitors are doing. And we just don't have the time. You know, we're not out there buying our clients' competitors' products all the time and comparing them unless they ask us to. On the trademark side of things, on the other hand, a real important thing that we can do is what's called a watch service. It's basically where we're just keeping our eye on all the trademark filings that look or sound similar to our existing clients' trademarks. And I get like an email once a day of all the clients I'm tracking, and I just go through it. And if one of them looks like, oh, here's a freedom trail, I should probably pick up the phone and call Dylan about this. You know, this is a problem. He needs to know about this. But you got to pay for that service, because it does take time and effort. But that's a real important way of paying attention, particularly on the trademark side of things, because if you don't follow through on infringing marks, then your trademark rights are going to be diminished over time and potentially go completely away. because at that point, if we think back to what we were talking about before, this is all from the eyes of the perspective of the consumer. If consumers are inundated with free trail trademarks out there, then there's no reason for them to think that, oh, this is Dylan's company, or this is the original free trail, or anything like that. So if we don't stop those third parties from infringing, then over time you could lose your rights.
And so then it kind of starts with a cease and desist and escalates to potential litigation if there's no settlement.
That's right. Usually starts with a letter either from the lawyer, or even, depending on the industry, depending on how severe the infringement is, it might start with a phone call from the founder or the CEO or whatever to try to massage it without getting the lawyers involved. It really depends on the personalities of our client, the personalities of the competitors that are infringing, depends on the industry. I've done a little bit of work in the craft brewing industry, and that industry is really interesting. And whenever there's a trademark dispute in craft brewing, it blows up in the craft brewing media. And because craft brewing is supposed to be collaborative, and we all just want to get together and have a beer. So we've got to really take the industry into account when we're writing a letter, right? And the specific situation where it's not a one size fits all, particularly in today's social media age where anything can be posted and backfire against the company that's sending it.
I've seen that happen a bunch in the bike industry where Specialized would try to protect some random thing, and they'd be essentially attacking a tiny bike shop in the middle of nowhere that's whatever,
Yeah,
and then
Specialized
everyone loses their mind.
kind of has that reputation, unfortunately. We used to represent, I don't know if you're familiar with the company Velagi, which is a bike company that it's been 10 or 15 years from now. They didn't survive because their founder unfortunately got hit by a car while cycling. But this was two engineers from Specialized that left to start a bike company. And they had some really innovative designs on their frame, and they were kind of one of the first to put disc brakes on road bikes. This was 10, 15 years ago. And Specialized was really not happy with them leaving and starting a bike company. So Specialized sued. Specialized won and was awarded $1 for for these guys having left and started a competing company. So that was an interesting story.
That's maybe an interesting thing to talk about too, because at the end of the day, the government's job is to promote competition, right? And so that's why a lot of these antitrust cases are brought. At least that's my understanding. You can confirm or deny my characterization here, but is that the consideration of the government when these sorts of things are being discussed, like the balance of protecting the IP and innovation of particular brands versus allowing multiple players to exist in a marketplace?
So I'm not an antitrust lawyer.
Yeah.
It's a very complicated area of law. Intellectual property does not come into it quite in the way you're saying and what we're talking about. What comes in for the competitiveness is not the ability to, for example, patent something, but it's to protect consumers and make sure we have enough choices out there, right? The one that's in the news, at least here locally right now, is Kroger and Albertsons, right? If they're allowed to merge, does that mean me in Southwest Portland only has one grocery store brand they can go to, which means they can hike up the prices? It's not good for consumers. Interestingly enough, patents are kind of the flip side of that, because patents give you a monopoly on something. It's the government saying, here is a monopoly for 20 years for being innovative. So it's kind of the flip side of antitrust, but it's to encourage innovation. Theoretically, you can have debates whether it truly does that, particularly in the high-tech industry and stuff. But it's kind of the flip side of antitrust.
One of the other things that, going back to the enforcement side of things, there's a whole thing in the bike industry of going to Temu or at Amazon and finding kind of like a knockoff of a specific product. And we see a lot of that stuff coming through. Do you see in the clients that you work with, when it comes to Amazon or Temu or any of these other websites that kind of sell similar products? I mean, is that
We
does that
do,
take you?
and it can be a whack-a-mole, but the great thing about the sophisticated platforms like Amazon and Temu is they have intellectual property policies in place that we can use and utilize to help our clients protect not only their brands but their patented innovations. A great example is Helinox. I'm not sure if you're familiar with Helinox, but they make camping furniture. They're out of Korea. They were kind of the first ones. I was going to try to show you a chair, but for the listeners at home can't see it, but there is a Helinox chair up there. You probably recognize the look of it because a few years ago there was just a proliferation of knockoff chairs. And fortunately, our client does have a patent for that technology, for the way it's constructed and the way it's put together. And we've been successful in probably taking off thousands of chairs off of Amazon using Amazon's internal patent dispute resolution system, which, I can spend half an hour of my time as an attorney looking at a product online, potentially buying it, analyzing it, submitting an Amazon takedown, and getting rid of that product. Whereas filing a lawsuit, going all the way trial may cost $1 million. I just spent a few $100s of my client's money and got this competitor off of Amazon. Now, it's just Amazon. It doesn't get them out of REI. It doesn't get them out of Dick's Sporting Goods and things like that. But Amazon has become such a big retail platform for every brand now that if you can get them off of Amazon, you effectively may get them out of the entire country because it's not going to be economic for them to still be importing products in the smaller numbers that they would need to go to brick and mortar retail establishments. So that's huge. Another client we do that for, Elevation Lab. They're a Portland company here that makes Apple accessories, high quality, high design Apple accessories, a lot for AirTags and sticking AirTags on sports equipment, on soft goods, things like that. And we've started seeing a huge number of copycats online. And so we've been successful in getting rid of those on Amazon.
Wow.
Awesome.
Yeah, it feels like that's going to be increasingly more of part of your job. I feel like
it really is.
as
Yeah.
more and more of just like transactions become e-commerce transactions, and
yeah.
I mean, I guess. Go ahead, Aaron.
Professional whack-a-mole.
It really is. It's professional whack-a-mole. And there's third-party providers out there that help brands just scour the internet for infringement and do that kind of thing. Sometimes you need to get the lawyers involved for more sophisticated things on the patent side, for example. But there are lots of providers that search for trademark infringement and copyright infringement, things like that.
So what's the right time for someone to come to you specifically to start, whether it's a patent, trademark, any of this stuff? When's the right time for this conversation to actually start?
As soon as possible, basically, right? Because if you get too far down that path of branding and it turns out you're infringing someone else's rights, that is a huge waste of time and money. Same thing on the patent side. We get a lot of inquiries where a small product company, they've been on the market for a couple years, they're finally getting traction. Oh, now it's time to apply for a patent. We're doing really well here. Well, it's too late to apply for a patent. You've been out there for more than a year. And so as soon as possible, we don't charge for initial consultations. Just having these conversations like I'm having with you today about the basics and about how the basics apply to their particular situation, they're going to be informed and be able to make the business decisions of where can I invest in intellectual property now so doesn't come back to haunt me later.
Well, this feels like a great primer, Ian. Maybe we'll have you back when we take our new startup out of stealth and we can be transparent about the process.
That'd be awesome.
Of protecting our new thing. Maybe in closing, did you bring a BPC with you, Mr. Gates?
I did. I did bring a BPC.
All right. So before we get to that, just in closing, let people know where they can learn more, where they can find out about your operation if they're interested in enlisting your services.
Yeah, so we're at KRDGLaw.com. We are exclusively an intellectual property law firm. We're located in downtown Portland, right on Pioneer Square. And that's all we do. We love working with product companies. I'd say if we had a niche, it's the outdoor product space, consumer space, and love working with founders and innovative folks.
Awesome.
So please reach out.
Awesome. Thanks so much, Ian. All
Yep.
right, the floor is yours.
So
BPC.
my
BPC.
so my BPC for today is a client, Nix or Nixware, KNIX. They just launched a media campaign with Megan Rapinoe, and Nix makes period underwear and period apparel. And it turns out that, according to this campaign, 1 in 2 girls quit sports or avoid sports because of their period. And so, this is an interesting thing they're doing with Megan is basically they're offering to give any pro athlete out there a check for $2,000 to mention that they're performing on their period. And so it's kind of a cool branding thing, but I thought you guys might like to get into that unique way of promoting a product, because it has nothing to do with, well, their product is period garments, and they're getting into the athletic and performance wear. So I thought it was kind of neat.
That is really cool. There's this concept of first, best, or different, and I feel like this one really stands out. They probably don't have a ton of competition. I mean, I'm not extremely aware of this space, but the fact that they can reach so many people and work with just about any athlete, I can't imagine there's a lot of exclusivity going on in that sponsorship category
That's right.
at this point.
Yeah.
So they can really kind of work with everybody, which is really fascinating. It's similar, Dylan, how we were talking about the bandit running thing, where anybody who's unsponsored that could potentially work with them. In the same way here, if you don't have that category filled, they can pretty much work with any female athlete in the world in any sport. That's huge.
Yeah, it speaks to another meta narrative that we've had on the pod about the ascendance of women's sports. And now we've talked about Avali, who's very focused only on women's volleyball footwear. Now Nix, and in general, I mean, like the WNBA just took on a bunch of new investment at a huge valuation. And yeah, it's, I think, something that is only good things for youth sports and for professional sports, is just the ascendance of women's sports in general. Lucy, you want to bring a BPC to the table here?
You betcha. That's awesome, Ian. That excellent BPC. Nailed it.
Thanks.
Perfect. I want to bring up the decathlon activation they had yesterday. I believe it was yesterday, or no, I'm sorry, Friday. If you're not familiar, there was a huge business outage because one of Microsoft's vendors pushed an update and it basically canceled everybody's computers on a Friday, to the point where it wasn't just like a simple update. And Decathlon moved lightning fast on this because everybody's laptops blue screened, which basically means like you bricked your thing. You can't even do anything. And Decathlon quickly made an ad that made the TV screens and a lot of the outdoor, screens have that same look, except it said outage, get outside, and then it had like a 50% off thing on shoes. Just taking advantage of the moment there. It's got a little hint of that anti-brand, like hyper fast response to something that probably happened. I mean, they had these ads up probably within a couple hours of the outage actually going down, which is like crazy fast turnaround. And it just fits so perfect. Like all these people who are working in business on Friday, and it's just like, well, time to get outside. Your computer doesn't work. I think it was genius.
Really, really smart. Okay, I don't have a great one this week, guys, but I just had Rod Farvard on my other podcast, the Free Trail podcast, with which Ian helped me to protect. And he was talking about super shoes in trail running and the fact that 17 out of the top 20 finishers at Western States, so 9 out of the top 10 men and 8 out of the top 10 women, were wearing carbon plated trail running shoes. And to this point, people had the assumption that super shoes were less of a relevant innovation for trail running. In other words, there wasn't as obvious of a performance increase as there was in the marathon. But this little anecdote, I think, is going to make a lot of people reconsider that fact. And actually, it made me reconsider. So in my Speedland shoes, I have been putting the carbon plate back in after, 2 years of very rarely using it. And, subjectively, I do feel a little bit faster. And as an aging guy, I'm like, you know what? I need to be putting the carbon plates in these shoes. I need any advantage that I can get. But I think that's sort of,
And even if it's mental, you're in a mental sport, so why not, right?
exactly. But it is pretty cool to be able to put the carbon in and take it out. So anyway, I didn't bring a good one with me, and that's the one thing that has stuck out in the last week as it relates to my sport and the products that I use, is just putting that carbon plate back in my GS SFDs and feeling a little bit more springy out on the trails. So
you're celebrating Speedland's utility patent. That's what this is all about.
Perfect. All right. Well, Ian, thank you so much for coming on the pod, buddy. Again, what was it?
KRDGlaw.com.
KRDGlaw.com.
And I'm Ian at KRDGlaw.com.
There you go. All right. Send Ian an email. Go protect your stuff. This pod is about building brands, businesses, and careers in the outdoor industry. Ian has helped both Aaron and I do that. So appreciate you coming on the show. Lucy, any closing comments?
Just a big, giant thank you to Ian for all of the help and, most importantly, all of the patience over the last couple of years. Super appreciate you, man.
Love you guys. All right. Thanks, guys.